Today the topic is the defense against trademark infringement. Since we have talked about the trademark infringement, it's from the point of the trademark holder, and then we say trademark holder. The holder means he is the trademark right holder or right owner. And in the last week, we have talked about from the trademark holder point of view, we say the trademark holder is the plaintiff. He will allege that the defendant infringe his trademark right. But this week we want to talk another viewpoint from the defendant. The defendant can say that even I have infringed your trademark, but I can raise some defense. So this is our topic today. About the defense, trademark infringement defense, there are several types in Taiwan's law, also in the United States law. I try to list several defense types as follows. The first is descriptive fair use. Descriptive, which means you use the trademark to describe something, not use it as a trademark. The second is nominative fair use. Nominative, which means you use the trademark to refer someone else's goods, not you use the words to refer to your own goods. This is the second fair use. The third defense is functional necessity. It's the use of this defense is very few. And the fourth defense is good faith prior use. But your prior use must be good faith prior use. The good faith prior use is some kind of compromise between the register requirement versus the non-register requirement, such as in the US. So it's a compromise, which means someone, although someone has used at first, but he not go to register his trademark, and another one go into register his trademark, and under Taiwanese trademark law, we protect one who go to register his trademark. We not protect who does not register their trademark, but we have to compromise these two persons conflict. So even someone has registered, but the prior use, the one first prior use, he can raise defense against the registered trademark owner. The fifth is exhaustion of right. Also, we call doctrine of exhaustion. Exhaustion, the translation is here, exhaustion of right, which means the copyright, the right of copyright, the right of trademark owner after the trademark holder sell his goods to others, then the buyer resold the goods to others. The trademark holder cannot sue against the reseller. Okay, the fifth, the 1 to 5th, that are provided in our Trademark Act. And the last is the artist or expressive use and parody. The artist expresses, you can see here, artist expresses use. And parody here. This type of defense is not listed in Taiwan's Trademark Act. Also, this type of defense is not listed in United States trademark law, but from the, as we all know, the U.S. Very focused on the protection of free speech. So the U.S. Code use the free speech doctrine to protect someone creator. So if the creator creates some work by using other trademark, they can raise the artistic or expressive use defense by arguing that it's their freedom of speech. And I said that in Taiwan we also have no such defense in our trademark law, but in the court judgment and in the academic literature, we many people like to discussion this kind of defense because it's interesting. Okay, there are six type of defense, and we will explain each one later. The first one is descriptive fair use, which is stipulated in Article 33A. In Article 36, provided that registered trademark shall not entitle the proprietor to prohibit a third party from what list follows. I should note like the proprietor. In English, it should be trademark holder. But you say the Chinese does not mention the word the proprietor. In Chinese, I think it should be here, like okay. I think the Chinese word, the subject is the defendant, I think, in this sentence. So in this sentence, they don't mention the proprietor. Okay, we just look at the English term. So the first first defense is descriptive fair use. It states that you use the term, you use the trademark, others trademark, but you use it to indicate her own name or other term, shape, quality, nature, characteristic, intended purpose, place of origin, or any other description in relation to her own goods or service. Which means you use the term to describe yourself, not to mention, not to refer to others one's trademark. You use this term to indicate, describe yourself. But you do this activity must be in accordance with honest or good faith. Here, good faith or honest practice in industrial or commercial matters, and not use it as a trademark. Like what I said, you use it to describe yourself, but not use it as a trademark. Okay, this is the first type of defense, descriptive fair use. The second one, nominative fair use. Nominative fair use, which means you use the term to refer to others' good or service or others' product. We can see in the statute it said you use the trademark to indicate the purpose of use of goods or service in accordance with the honest good faith practice in industrial or commercial matters, where it is necessary to use the registered trademark to you use others registers. You use other registered trademark to indicate good or service of the others, the proprietor. I said the proprietor should be the other trademark holder. So in Chinese, we can say, you use others' trademark to indicate others' good or service where there is necessary. Why we use others' trademark to indicate others' good or service? We will see some example later. But have you ever been to? I believe that you all buy smartphone, right? You all have smartphone, and you go into some store, the store to buy the smartphone, and the store you will it often like the store they will put many others trademark in front of its gate or their sign or their wall, because the store want to tell you, the consumer, like the store sells many brand of smartphone, not only one brand, but maybe 6 different brand trademark of smartphone. So in this case, the smartphone store they use others trademark. Maybe they use 6 different smartphone trademark to indicate like the store has sell the 6 different brand smartphone. That's the typical case. So this is the normative fair use, but there is a limitation like it should not apply, which means the normative fair use should not apply if there exists a likelihood of confusion among relevant consumer as a result of such use. Okay, we have illustrated the first 2 defense. The first is descriptive fair use, and the second is normative fair use. But actually, in the real case, I think it's different. It's difficult to distinguish these 2. In some cases, sometimes you are not sure whether the case is belonging to the first one or the second one. Okay, let me use some cases. The first case is from the prosecutor office examination question. Okay, we read the question. Party A operated a Happy House Real Estate Corporation. The Happy House Real Estate is the Party A's the name of his company, and the Party A engaged in real estate brokerage and other service. What is real estate brokerage? You can see a real estate brokerage, and the trademark Happy House and the Chinese Happy House used by the Party A were registered as trademark as early as the year 2005. And the trademark designated for use in real estate leasing, sale and leasing agency, real estate appraisal, real estate operation management, or real estate brokerage, real estate sales consulting, real estate sales information, and other service. So the Party A registered the term Happy House and designated for use in several services. And but the Happy House Real Service, Happy House Real Estate. Later, the English translation have is something wrong. We can see the Chinese. The Party A registered the Happy House and Chinese Happy House. But in here, there are some words. The real estate here, real estate, have no distinctiveness. So when they register the trademark, the IPO require they to disclaim like the real estate not being among the exclusive term, which means although the Happy House Real Estate, the all these words are registered, but if you only use the real estate, the 2 words not protected, not among the exclusive right. Okay, that's party A. And the party B, on the other hand, is a franchise store of Company C. Company C is a leading domestic real estate company, hereinafter referred to as Company C. You guys in Taiwan, and as far as I know, the leading domestic real estate company, there are two. One is Xinyi, and the two is another one is Yongqing. And in this case, the party B is a franchise store of maybe Xinyi. Here, franchise store. And so, because the party B is a franchise store of Company C, so he in later advertisement they will use the company the name of Company C, such as Xinyi. So, but the Company B has its own legal status as a company. So, in order to distinguish itself from other franchise store of Company C, Party B registered its company name as Happy Real Estate Brokerage Limited. It's the name of the company name of the Party B, not their trademark, just the company name. With business activity including real estate sales, leasing, and brokerage. This is about Party B. So I draw some relationship between these three. One, Party A, he is a registered trademark holder, and Party B, Party C is a leading big company, and Party B just a franchise store belonging to the Group C. Maybe we can call the C Group C. So when B use in the advertisement, they always use the Group C's trademark, not their own. But the Party B has its own company, so the company name is the same as the Party A's registered trademark, just Happy House Real Estate. So Party A sued Party B, alleged that Party B use of his company name, infringe Party A's registered trademark. But so A accused like Party B infringement. But the Party B raised some defense. Party B, the defense Party B raised is the Party B just used its company name to indicate their company name. So the Party B raised the defense of descriptive fair use. The descriptive fair use, because they use the other's trademark to indicate his own name. That's the case. So we can see the detail. However, the party B is storefront sign and business card prominently feature the design logo and trademark of company C or group C in large font without using Happy Real Estate Brokerage Limited. Only in the bottom left corner of its website. Party B used in his website in the bottom left corner the Happy Real Estate Brokerage Limited. So the question is Party B's behavior considered an infringement of Party A's trademark right? Please elaborate on the relevant laws. So I have tell you the answer, like the Party B can raise the defense, and the defense is the descriptive fair use, because the Party B used the trademark just to indicate his own name of company. Okay, this is a first case. And the second case is a US case. Tiffany sued Costco. As we all know, Costco is the wholesale retailer, maybe biggest in the US, even in Taiwan, biggest wholesale retailer. So in Costco, we have seen the Costco sell many products, and they even sell many expensive products. So the Costco sell the diamond ring here, diamond ring. The diamond ring they sold are unbranded, which means they're not a famous trademark, not a famous brand of some big company. So they sell unbranded diamond ring, but they will a little label or sign in front of its product. In this little label, the Costco will show us the name of the product and the price here. But what at issue in this case is like the Costco use the Tiffany here, Tiffany, as the name of the product, and here also Tiffany as the name of the product they sold. But the product, the diamond ring, not produced by Tiffany. So Tiffany decided to sue the Costco. They say the Costco infringed the trademark of Tiffany, but the Costco said, explained why they use Tiffany in their label. They said the Tiffany just a style of diamond ring, not to indicate like the diamond ring from Tiffany, but just to descriptive the diamond ring style is Tiffany style. What is Tiffany style diamond ring? Which means a specific, a special style. As far as I know, they will 3 or 4 prong here, and below is the ring, and they will prong, maybe 3 or 4 prong, and here they will diamond put in the middle of the 3 or 4 prong, and we call this a Tiffany style diamond ring. So Tiffany didn't accept this explanation, so they brought the suit to Costco in the United States, and in 2020 the Second Circuit Court deliver the judgment. So now we read the case, the rule, the judgment together to see what the code say, and I use the AI translation to let you see. So we all can see the English paragraph, and after the below the English paragraph, you can read the Chinese paragraph. Okay, we read the we all together read the decision paragraph by paragraph. Okay, here opinion. From the opinion is the judgment, the ruling of the code. So the defendant is Costco. Sorry, I want to use another function. Okay, the plaintiff is sorry. The defendant. I have explained. The defendant is we call the sorry. I have to okay. Defendant is the Costco. Appeal from an August judgment of the district court, which means in the first instance judgment, the Costco lose. Lose the first instance judgment. So the Costco appeal this case to the Second Circuit Court. In the first instance court judgment, the court awarding the plaintiff Tiffany treble profit, prejudgment interest, and punitive damage totaling $21 million, resulting from the court determination on the summary judgment that Costco was liable to Tiffany for trademark infringement and counterfeit in violation of the Lemon Act. Lemon Act is the federal trademark act, trademark law of the in the U.S. And here the suit arose from the Costco sale of otherwise unbranded. Unbranded, I said, unbranded diamond engagement rings. But the Costco in the point of sale sign, I have said it's label, a paper label. I change the color. Okay. The Costco write in their point of sale sign, a paper label contain the word Tiffany. So Tiffany claimed, and the district court agreed that Costco's use a term identical to Tiffany trademark in connection with the sale of engagement rings violate the Lemon Act as a matter of law. So the Costco decided to appeal. In this appeal case, the Costco argued that Tiffany is not only a brand name, but also a widely recognized descriptive term. for a particular style of plunged ring setting. Plunged ring setting. Sorry, I have to. I want to use the AI to pronounce this word.
Pronged ring setting, and that it used the word on point-of-sale signs solely to identify engagement rings and rings incorporating such settings.
Okay, plunged ring setting. So Costco's, sorry. The Costco argue like the Tiffany, the word is just a descriptive term for a particular style of plunged ring setting. And the Costco use the word on point of sale sign, the label, solely to identify engagement ring incorporate such style, such setting. It emphasized, among other things, that it also saw several other styles of unbranded diamond engagement ring identified by similar point of sale ring, each of which indicated the name of the corresponding ring setting style, and none of which used the word Tiffany. So, that's the argument, the defense from Costco. That's the factual background, as we have all know. So we jump to the ruling of the code. Discussion here. Discussion is the ruling of the reason of the judgment. But there is at first the code have to decided like whether the use of Costco infringement of the Tiffany trademark, which means it have to determine like whether there is a likelihood of confusion, as we have introduced several weeks. Here. Sorry, I want to show you some information. When we say someone infringes others' trademark law, the code have to determine like if there is any likelihood of confusion. And we have introduced that in different circuit code in the United States. They use the different code use different factors to determine where there is the likelihood of confusion. So this case, the Tiffany versus Costco case, is before the second circuit code. The second circuit code will use the parallel case 8 factors to determine where there is a likelihood of confusion. So back to the case, the code at first have to determine like the Tiffany's infringement claim. So the code say under the Lemon Act, a plaintiff alleging trademark infringement must demonstrate that 1. It has a valid mark that is entitled to protection, and 2. The defendant action are likely to cause confusion with that mark. So and we have said what the definition of the likelihood to cause confusion. I say there are two meaning of. I have said like there are two meaning of likelihood of confusion. The first one is small. How to say? Smaller meaning, and another is broader meaning. In the broader meaning, I have said the confusion not confusion from the same origin, but the confusion about the affiliation, connection, or association. So in this case, maybe the Tiffany alleged like the activity or the action of Costco may even they don't constitute the small meaning of likelihood of confusion, but maybe it will constitute of the broader meaning of the confusion, such as the confusion of affiliation, connection, or association. So we see the paragraph here. With the first prong of the infringement inquiry, presumptive satisfied because Tiffany is a registered mark in the United States. So then they have to evaluate the second question. That is, if there is a likelihood of confusion, and as far as I have mentioned, like in the second code, they will use the period factor, 8 factors, to determine whether there is a likeliness of confusion. The 8 factors which is 1, the strength of the trademark, 2, the degree of similarity between the plaintiff mark and the defendant alleged imitative use, 3, the proximity of the product and their competitiveness with each other, 4, the likelihood that the plaintiff will bridge the gap by developing a product for sale in the defendant market, 5, evidence of actual consumer confusion, 6, evidence that the defendant adopted the imitative term in bad faith, 7, the respective quality of the product, and 8, the sophistication of the relevant population of consumer. Here is the Chinese translation. And in this case, the Second Circuit Code, think the most important in this case, not all these 8 factors, but only 3 most important factors in this case. So I see. So here, on appeal, Costco principally contested the district code analysis of 3 of these facts. Only 3. They argue like the district code analysis is wrong. First is whether Costco's customers were actually confused. And 2 is whether Costco adopted Tiffany mark in bad faith. 3 is whether the relevant population of consumers were sufficiently sophisticated to avoid confusion. just these three factors, they have disagreement. There are disagreement among the Tiffany and Costco. So we try to emphasize the three. First, is the actual evidence of confusion. The two is whether the Costco use is from bad faith. And the third is the consumer sophistication about this product, which means because the diamond ring is very expensive, and before you buy such expensive product, you will do much homework, do many research work. So Costco think if the consumer want to buy this expensive product, they must be very familiar with this product. They will not be confused. Okay, we focus on these three factors below. First, if there is actual confusion, let's see. The Tiffany point to two evidence. First, it referred to the deposition testimony of 6 Costco customers. They testify, the Costco customers, they testify like he or she was confused by Costco's point of sale signs. Second, it described the result of a customer survey, and the report created by Tiffany expert Dr. Jacob. Dr. Jacob report included response from 944 people surveyed through the internet, and there are 306 of them identify themselves as Costco patron, which means they are Costco's customer who sold like they or their significant others would consider buying a diamond engagement ring at Costco, like cost at least $2,500 US. Jacob estimated that these 600 responders, each of whom was shown a photo of a diamond engagement ring alongside one of Costco point of sale sign. It means they use the sign here to show to the customer, and either in isolation or after seeing photo of other branded items sold by Costco, more than 2 out of 5 here were likely confused into believing like the Tiffany company was the source of the ring. It means that the 2 out of 5 will be confusion. So there are two here. The Tiffany submit two evidence. The first evidence is there are real 6 customers be confused, and another evidence is there is a consumer survey. So the district court deemed these 2 evidence unrebutted, and concluded that the Costco had failed to raise a factual question as to whether customers were actually confused by its use of the word Tiffany on its sign. But the second court disagree. Why they disagree? We see to begin, Costco did seek to rebut Tiffany's evidence of confusion. First, it argued that the testimony of 6 customers out of the 3,350 customers who purchased Tiffany set ring at Costco during the relevant period was only de minimis evidence, which means in this time there are 3,350 customers who purchased, but only six customers who said they were confused. So the proportion is very small. Second, and more important, it submitted a report from its own expert, Dr. Russell, criticized Dr. Jacobo's survey methodology and the result. And Dr. Winner. Dr. Winner pointed out Dr. Jacob should have targeted only customers with a present purchase interest in buying a diamond ring. He means like if you are not a rich person, if you are not rich, you will not purchase diamond ring in Costco. So only only the rich people will buy diamond ring at Costco. So it means the Dr. Winner think you should only survey the rich people, not the poor people. And the Dr. Jacob actual survey respondent could not have been a group whose percentage provided any valid or reliable predictor of past or future cost of diamond ring purchase, because these people, they have no money to buy this expensive product. And Dr. Winner further asserted that Dr. Jacob's study was fatally flawed due to artificial contributed and biasing, blah blah blah. So the court concluded that this evidence was sufficient to raise a question as to whether potential buyers of Costco diamond engagement ring were actually confused by the appearance of the word Tiffany on Costco sign. Okay, I have to explain right here. This case is a summary judgment. Summary judgment. The summary judgment means there is no jury. If there is no issue of fact. But here the second code think there is a question about the fact issue. The fact issue is whether there is actually the consumer actually be confused. That's a factual question. So if there is factual question, then they need to submit this case to the jury, not decided by the court, the judge themselves. So the second code, the conclusion is like the evidence was sufficient to raise the factual question. That's enough. So this case should go back to the jury. Okay, that's the first factor. And the second factor is the Costco's, whether the Costco do this action is from good faith. Okay, but I have mentioned, like, I think when determine the likelihood of confusion, we should not focus on the good faith of the defendant, because when we determine like whether there is a likelihood of confusion, we should focus on the consumer, not focus on the defendant subject, good faith or not. So I skip this part. But we can see the conclusion in this part. In conclusion, no, we skipped it. And the third factors, they focus on the consumer sophistication, which means, I think if you buy an expensive product, you will do much search homework before you go to the store buy this expensive product. So you must be sophistication more than average normal consumer. So here, the second code says, when the more the buyer, more sophisticated. Here, the more sophisticated the purchase, the less likely he or she will be confused by the presence of similar mark in the marketplace. So here the second code said, we have previous recognized, like, the purchase of the diamond ring, particularly of a wedding or engagement ring, will be most discriminated in his purchase and make it carefully and deliberately, which means they will very carefully and they will do much homework search. So a jury could reasonably conclude by crediting Costco's evidence and rejecting Tiffany's, like the relevant population of consumers would be sufficiently attentive and discriminating as to recognize Tiffany had nothing to do with Costco's diamond engagement rings. Okay, till now we just finished the part of the infringement, the discussion of whether there is infringement of trademark.